Your Lordship's request. But the thing is this, the opposite party.
What is the suit? What
There are
is the
two
suit for?
suits. One for eviction of the sisters from their ancestral property, filed by the brother. Brother claiming the same through a will. Will has not been probated. Probate is pending. We are contesting the probate.
Oh, yes.
And that is a subsequent suit. The eviction is a subsequent suit. Prior to that, there is a partition suit. We filed a partition suit.
You are claiming interest on the basis of a will.
I am not. They are. We say that there is no will.
You are the daughter.
We are the daughters.
He is the son.
My lord,
Yes,
it's a
son.
son, my lord. My lord,
Eviction suit filed by whom?
By
eviction
the
suit
son, by the my brother,
File a eviction
my
suit.
brother.
The partition suit has been filed by them, my lord. Now the subject matter of the
You have on the basis of a will.
not a basis, on the basis of the settlement, deed of settlement.
Deed of
That's the deed of settlement that has been right title has been conferred upon me.
Mm.
Now, my lord, kindly take up the order of the trial court, my lord.
What the trial court has done.
My lord, the operative portion, my lord.
Yes. You had filed. Who had filed a Section 10 application?
My application.
Your suit is a prior suit.
My suit is a prior suit. Partition.
Partition suit. And
File.
his suit is for eviction.
Eviction. my
Eviction.
lord. I am claiming an ownership. And
How do you say that
And it-
trial court has rejected it?
my lord.
That was the subject matter challenge in this revisional application.
Must have rejected it.
My lord.
The defendants have filed counterclaim. You have filed counterclaim in his suit.
Claims.
Partition.
In the partition.
In the eviction.
Sir, Mr. Shamanto, what are you confusing? You have filed counterclaim in the eviction suit.
With the eviction suit and also
What is your counterclaim?
that
Wait,
challenge is deed of settlement.
challenging the deed of settlement.
Yes.
That is it.
I say, my lord, there is no deed of settlement, and even there is no will also.
That is
So what is the wrong in the order?
Lord, my
Mr.
suit,
Shamanto, what is the wrong in the order?
my suit is
Your suit is for partition.
yes,
Try and understand.
my lord.
What I can do is I can direct both the suits to be heard together.
That can be
direct
done.
this.
Well, prior to that, will not kindly visualize one thing. The brother filed two probate proceedings. One
Hey,
Yes.
it is this matter on Thursday under
What?
the heading. List this matter under the heading returnable motion on Thursday.
Thursday.
Hey, next Thursday, yes.
Yes, yes.
Because this is a returnable motion, not an extension anymore. I'll tell you.
It's must
I'll
not
pass
be
an order on
extension,
Thursday.
my lord.
I'll dispose it of.
My lord.
Mr. Shamanto,
My lord.
take instructions from your client. Very clear. So far as this matter is concerned, I'll direct both the matters to be heard together. No stay, cannot be any stay. He's an independent right of eviction. You are a partition suit.
Yes.
Now, assuming, please understand, Mr. Shamanto, tomorrow you fail in the partition suit. He has to start afresh.
Yes.
Tomorrow you fail in the partition. So both will go together and judgments of both the suits will be passed simultaneously.
But the one thing, my lord, they claiming their ownership by two ways. One from the deed of settlement, another by way of a will.
Let
Which is-
them,
which is-
what stops them?
That's
My
a
lord,
matter
will
of
has
trial,
not
my
been probated you.
What stops them? But what I will not do, you see, probate, so far as probate is concerned, that he
That
cannot
is contested by us.
establish his right unless probate is he gets a probate.
Yes.
So, okay, the probate proceedings is also contested by you.
Not initiated by me. I say there is no will. That is disputed by me. There,
But if he succeeds in the probate, everything
there are cannot.
your partition suit fails.
Yes, but that's why, my lord, my contention is, my lord, let the probate proceeding be disposed of first, my lord. Then this will.
Proceeding is not the subject matter. There are two suits over here which has
His claim is not independent. No, his claim is not.
title suit.
Cannot be independent, my lord. He cannot claim in both the ways, by both the ways.
The title suit.
Very well, come on Thursday. Sabeshpatival diye do. Call the next matter.
My lord, under the heading, my lord.
The returnable motion.
My lord.
Very compelling circumstances, my lord.
Returnable motion. Yes, call the next matter.
Returnable motion.
Compelling
Yes.
circumstances.
Sorry, sir. Matter is going on. What is this? Sir, this cannot go on like this, sir. Sir, have you, sir, you are a senior person, sir. You have been practicing in this court. Can you go and mention? What have you to mention? It cannot wait. Tell me. What have you to mention? Tell me. What are you trying to mention? Tell me. No, you tell me what are you trying to mention?
I have mentioned the matter on Monday.
What are you trying to mention now in midst of the matters? Tell me. It cannot wait. Sir, what is this going on? Where are you trying to bring this court to? You should be sorry, sir. Yes, item number 2.
I appear on behalf of the respondent. I'm led by Ms.
Sen.
Sen.
Yes. Where is your client?
My lord, he's just on the way. On the way, lordship, consent order, lordship can pass.
No, your client is there. I'll pass that order. Your client is aware of the order. I had the interaction yesterday. That when it be suitable for your client, ask him to take that leave, monthly leave. When it be suitable, end of the month, ask him. Ask him.
Yes, sir.
Answer to your advocate. End of the month, will it be suitable?
To be flexible considering the minor child's schedule, school schedule regarding exams.
Too young. Cannot be flexible. That will create complications, madam. Because the mother will say, I don't want on this period. The father will say, I want on this period. Look, their relationship is not very good. It is hard. Let us accept the position. So I think unless the court fixes this, it will be difficult for them. And the entire this the setup will fail. Object will fail. Because you are dealing with human lives and this child is involved. The child will be having a mindset to go. And then it does not happen. It becomes very tricky situation, madam. So what I'm proposing is, on the last Thursday of the month, he will start from his residence after his office hours. That is what is discussed yesterday. And on the next day, perhaps the son will reach in the morning. Your daughter. The child will reach in the morning. That is what was agreed upon yesterday. Okay. And so it's a Friday, the child reaches last week. On the last Thursday of the month, whatever is the date, sir. Madam, okay. Your client starts from his residence. 7 hours journey or 22 hours journey, but it is a journey. He has to come from Shillong to Guwahati. So maybe less also. He has to come from Shillong to Guwahati. From Guwahati, he has to either take a train or a flight. Flight is not available to Malda. So he has to take a train to Malda. That will take around 7 hours. 7 hours easily to Malda. And from Malda, drop the child at the residence of the mother.
Yes, there is some due to some inadvertent.
Ordinarily ought not to be. He has to make sure, because he will be dropping the child. I am not asking him to again come and collect the child. It will be the obligation of the mother, to drop the child at Guwahati, at his residence.
Expenses should be bared by the mother when she is transporting the child back to.
Naturally, I've indicated that. These are all decided. Where is Miss Sen?
She's on her legs before court.
Very well. So I will do this. His leg of the journey, he will bear. Her leg of the journey, she will bear. And she will drop the child at the residence of the petitioner. Mother-in-law will be there. So there is no difficulty. It's not necessary for him. She'll start on Tuesday, Friday, Saturday, Sunday, Monday. She'll start on Tuesday. and she'll reach on Wednesday. Until the child reaches the age of 5. What is the age of the child? What is the date of birth of the child? Tell me the date of birth.
11th July.
My lord, lordship is.
For the timing, sir.
No, 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 no. The last interaction it was held, but this is for 5 days. 5 days.
Yes, so 5 days only.
No, 5
No,
days.
no, not more than that. Otherwise,
No,
the
no, no,
suffer,
no.
child will
But
suffer.
it is 4 days, my lord. Lordship is-
Actually, whatever. I think it's enough.
The child is
For the timing, enough interactions, sir. For 6 months. Thereafter, if situation will be reviewed and it will be understood. He understand this will be without prejudice to your rights and contentions in the main custody application. I will provide for that. This is only in the best interest of the child that I am passing this order. And I will record consent to this extent. To this extent. But without prejudice to the rights and contentions. Where is your client? And you have to give the opposite party is required to give an undertaking. So would the petitioner. Where is your client, man? Sir, where is your client?
My lord, my client is on the way, my lord. My lord, he is staying at a, my lord, in distance place in a hotel.
Sincere about the
No, he
this
just-
order.
Yes, yes.
Why she is not in time?
My lord, he is staying
Maybe
somewhere in Korea in a hotel.
she
In a hotel, my lord.
more time to reach
Yes.
from her residence to
I know
Shillong.
Absolutely, absolutely, absolutely. My lord, I bow down
She
before
cannot
lordship.
fail a day.
Lordship, so what is lordship's
I'll
fault?
ensure the undertaking comes here.
Yes, yes. I will give that undertaking. I'm just ask my junior to call him.
Challenging Yes, chalo. I'm grateful. You go through the order. If you have any difficulty, come back.
Grateful, Your Honor.
Both of you.
Lord, this is my petition coming up for the first time. Lord, I own a flat, 2,300 square feet in Lord Sina Road in a very good complex. I had let it out on leave-in license for 5 years to the defendants in the suit. My rent was 50,000 a month. The agreement came to an end in November 2021. In March 2022, I filed a suit, eviction, mean profit. Leave-in license 5 years over. In that suit, I
Where
filed
is the property?
Lord Sina Road, my
Not
lord.
Sina.
Ankur
And square feet
Apartments.
is
About 2,300 square feet.
2,300.
Good posh building, my lord. Distinguished persons
5
live there.
years. For
5 years, 50.
Leave-in license.
Yes, leave-in license 50,000 a month.
Yes. What happened?
This is the check amount. I don't know the actual.
Where that's
hey.
So yes.
Now, 5 years over, the leave-in license agreement expires by paucity of time. By efflux of time.
File a suit for recovery.
For recovery of possession and mean profit. Now, my lord, in that suit, I made an application for occupational charges at the contractual rate of 50,000 per month.
That has not been granted.
The arrears until the date of my application, plus a prayer that 50,000 they must continue depositing
That
until
is agreed. That is agreed.
until disposal.
50,000 was agreed.
Yes. That's not denied. Now, my lord, kindly see page 175. Just 2 pages I will show, my lord. This
No,
is
the
my
plaintiff landlord are entitled to get a sum of rupees 7 lakhs. Occupational charge. What is 7 lakhs?
my lord, I will tell your lordship. 50,000, my lord, for 14 months, or I believe number of months comes to 7 lakhs.
Okay.
But that is as on the date of my application for getting occupational charges.
You are saying that it should have been directed that continue to pay on till such time. the
Because
suit
that is the prayer. Kindly see page 175. That is the prayer. And the learned, my lord, court below in its order even observes that the prayer is until the end of the suit. But while at the end, my lord, the observation is
serve and come.
completely contrary.
Serve and-
My lord, I will serve and come. Also, my lord, my grandfather, the original, my lord, licenser was my grandfather, who had.
In this matter, lower court, we are respondent number.
I'm so grateful.
Lordship, we have not served a copy of the application.
My lord,
Same
And a copy of the
my lord,
judicial
my lord,
application.
one of the
miss out on
parties.
Miss
Priyanka Gorai.
Miss Bhattacharya.
My lord,
Priyanka Gorai.
Miss Godai,
your
learned
lordship may
advocate,
record. I have handed over right away.
learned advocate who enters appearance on behalf of the opposite party. Only one opposite party.
Oh no, my lord, there are two. One
On
Behalf
is
of the opposite parties.
No.
Appear both.
What court?
my lord, may I just clarify? My lord, one opposite party is my friend, the
Yes.
defendant in the suit. The other opposite party is my grandfather, because the
Not
original,
necessary, yes,
I was gifted the flat.
very well.
My
On
2 weeks
behalf of
ago,
the,
he passed away.
Appears on behalf of the opposite party number 1. Appears on behalf of the opposite party number 1. Full stop. She also accepts service of the copy of the revisional application and undertakes to file. Wakalat Nawa. Madam. Bye.
By Lordship, 10 days? 1 week? My lord,
By Monday.
my lord, give me 3 days at least time. 3 days at least.
Why? I'll place the matter on Tuesday. Unless you file Wakalat Nawa, I cannot. What remains in the matter?
Lordship, I'm led by Mr. Varun Kothari.
That's very well, madam. You are the advocate on record?
Yes, Lordship, I'm the solicitor.
Correct. You are the advocate on record, madam.
Yes, Lordship.
Are you understand the matter? What the matter is? Have you gone through the papers? No.
Lordship, no, Lordship.
Very well.
I'm
Go through the
instructed.
papers and come back on Tuesday. ভাই কবে আছে দেখো তো কবে আছে দেখো দেখো তুমি দিতে না পারলে তাহলে পরের সপ্তাহে দেবো না থাকলে বেশি করে দিও না তাহলে হবে না আচ্ছা ঠিক আছে নেক্সট ফ্রাইডে হবে না তাহলে শুক্রবার
Friday, my lord. Friday is, my lord.
I don't take up on Fridays. These are the exceptions.
Wait.
Friday.
Deeply obliged.
Yes, you are there.
I am here.
Then I'll dispose it of today.
I do not have my brief. Your Lordship is
Sorry, what is there in the matter?
Lordship, I'll be very frank. I do not even have the brief now. So keep
The
it on-
occupational charges you will not pay.
Lordship, we're not saying that we will not pay. If there is
I'll grant you if there are arrears, How much is areas has fallen due? Any areas are there?
My lord,
7 lakhs.
areas were, my lord, 7 lakhs
Have you
until
complied with
January.
that? Have you complied with that?
Lordship, he had offered
They
that
have paid. They have complied with the order of the court below. Yes. they
And
have.
after 7, after that is still the application till date is filing.
January 2023 until
2023.
January
I'll give you
2023.
some installments, pay off the balance.
kindly keeps it on Monday and passes the order that your lordship is proposing. I'm handicapped today. Your lordship keeps it on Monday. I'll
Friday.
wait.
Friday. My lord, may I delete?
Within a week. Undertake
No,
within a week.
I-
So week means Thursday, madam. You file the vakalatnama by Thursday.
My lord, I must point out, my grandfather, the pro forma respondent, has passed away during pendency of this application. His name may be struck off. The pro forma
Your
respondent.
grandfather.
My lord, because
Where is his son and daughters?
no, my lord. My grandfather was, my lord, the person who had gotten into the leave and license agreement. It was
Yes.
his flat.
You are
During
claiming, you are claiming through
I'm-
your grandfather.
And the grandsons, the two grandsons,
Yes.
the flat was gifted to the two grandsons.
Registered.
Yes, registered gift deed.
Acha.
And then in the lifetime of the
Add a
grandfather.
line, add a line. Where is it? It's a death certificate.
So when the
Death
no,
certificate.
my lord, when the suit was filed, the grandfather has been
Where
impleted
is
as
the
a,
death certificate?
it is not, my lord, in our
And
hand.
without the death certificate, how can I record, sir?
My lord, kindly let it be.
But did he die prior to filing of the revisional application?
My lord, after.
After.
Otherwise, we would not have made him a party. After.
You either, if you're not brought in, you file 1-page application. For you file it, I'll post it for along with the matter. I'll dispose it on that date, Friday. 1-page application for deletion of the name, recording the death of the pro forma opposite party number 2.
Can we do it by way of a supplementary affidavit?
No application.
Very well. My lord, we'll move it in the meantime. My lord,
Not move it. Along with that, on the same date it will come.
by Friday.
Yes.
We will file it.
Give the number to my officer, it will appear.
I'm so grateful.
And you see, sir, the occupational charges 50,000 rupees was agreed upon.
Lordship,
Right? Eviction of licensee.
Lordship.
Correct. Now you are to pay that occupational charges. Without paying occupational charges, you cannot be permitted to contest the suit.
Very well, Lordship.
It's normal. Very normal, sir. You will staying there. Are you not staying there?
I'm occupying.
You will occupy the property. You will not pay. It's not reasonable, sir. So this is the order which I will pass. Unless you say that 750,000 was not agreed, but you have complied with the direction. So you can't say anything today.
No, written statement is filed. It's not denied that they were paying
No,
50,000.
they have 7 lakhs they have paid. So
Yes,
simple
they have.
matter.
Lordship. Next day, Lordship. kindly allow-
Yes, Friday.
Grateful, Lordship.
Next matter.
Lord, this civil division arises out of from arbitration.
What is the urgency?
Yes, there is an urgency, Milord.
Yes.
Yes, Milord, there is an urgency. Milord, may I just give a short background of the matter, Milord?
No, you kindly directly go there.
Milord, kindly come to the impugn order, my lord, is in at volume 2. There are 2 volumes, my lord.
Yes, what is the order?
Yes, my lord, the order, my lord, here, my lord, the order is, my lord, why, my lord, the background is necessary to ascertain the order, the nature of the order, my lord, it is necessary to.
No, why
understand
will
the
I
pub-
interfere under Article 227? It's an arbitration
Yes,
proceeding.
my lord, because this order is not appealable under any provision of law, my lord. And
What the order has been passed? Which page?
yes, it is appearing after 440, my lord.
Order
Second
number
volume.
12.
No,
Order number?
it's a certified copy, my lord. It starts from after 440.
Yes.
Volume 2, my lord. Volume 2 of my lord's brief, my lord. My lord, the findings, my lord, your lordship will get, my lord.
No, what is the direction?
My lord, the direction, my lord, what, my lord, the direction is, my lord, the learned tribunal, my lord, had that the present arbitration proceeding forms subject matter of the civil division is not a fresh arbitration. It's a continuation of the arbitration.
No, what she has directed, extension of mandate.
Yes, here, my lord, I am aggrieved. What is the matter about? My lord, my contention is that the arbitration initiated by the respondent in the year 2020 was abandoned by him, and I initiated a fresh arbitration after obtaining order under section 11 by this honorable court in 2024. Fresh arbitration initiated at my instance on a distinct cause of action, distinct relief. There the respondent appeared, filed a counterclaim, taking the claim which was filed as a claimant in the earlier arbitration reference initiated by him, which he abandoned according to me. He did not pursue the earlier arbitration proceedings. So in this premise, I filed an application stating reject his counterclaim because he cannot revive its claim which he had not.
Why will you
Pursued.
take to revisional jurisdiction? I will interfere, Mr. Hussain.
My lord, may I, my lord. I understand this is a hurdle, my
not
lord.
easy.
This is a hurdle, my lord.
Yes.
I understand. May I just give what
Yes, yes.
what prompted me to approach this honorable court, my lord? So in these circumstances, I filed an application before the arbitrator stating, look, this is my claim. I am the claimant here. This arbitration was initiated at my instance. The respondent did not pursue its claim filed in the earlier arbitration proceedings, so he cannot proceed. So he cannot
No,
maintain the
previous
counter.
arbitration proceedings was commenced.
Yes, it was commenced.
Section
They got interim order. They violated the order. They took possession of the asset in violation of the order. They did not do anything for 3.5 years in the arbitration. Ultimately, arbitrator got irritated and resigned from the arbitration. Thereafter, I repeatedly approaching them, you kindly revive the proceeding. They did not take any steps. Thereafter, it was me who pushed him for the second arbitration, and he became a party. And my lord, in earlier arbitration, I did not file any counterclaim. Only a defense was filed by me, and it was pending without any extension, formal extension, 3.5 years. Now, the second arbitration proceeding was initiated at my instance at a distinct cause of action because they violated the order of injunction obtained by them in 2020. They sold the asset. So I claimed damage in my suit, in my claim. There they appeared and by way of a counter claim, raised their claim, which was filed in 2020. There I raised objection that they cannot. They cannot because they abandoned whatever, even if they want to revive the earlier, they have a remedy. They can under section 15, after resignation of the arbitrator, they can revive their claim. It cannot be a bar that it has to be only one arbitration. They can always do that. But don't disturb my arbitration proceeding. This was my bone of contention there. Now, what the arbitrator did, now, my lord, the provision of law also states that under section 14, once the arbitrator resigns, the mandate will be terminated. And the only remedy for revival of the arbitration proceeding available under section 15. Under section 15, substituted arbitrator can be appointed, and the mode of arbitration, my lord, is shall be, which was the mode of arbitrator under section 15 only in the manner contained in the arbitration clause. The arbitration clause
How
provides.
was the arbitrator appointed?
My lord, the arbitrator appointed, my lord, the first arbitrator
Now
appointed.
this one.
The present arbitrator in section 11 application, my application, in 2024, January 2024.
At your instance.
At your instance, they did not appear.
So court appointed the arbitrator.
Yes. Court appointed the arbitrator. This is the situation. Now, my lord, if your lordship consider the section 15.
Now, what the arbitrator has done?
The arbitrator held, inter alia held, that no, this is a continuation of earlier arbitration. So I am terminating because it is beyond time. It's already 4 years. So you seek extension.
You apply before the court taking up arbitration matters and say this is not required.
My lord, my difficulty is, my lord, under section 29A My lord, they have already filed an application under section 29A before this honorable court, and that was adjourned till February next month by your lordship Justice Sharkar, on the premise that my 227 application is pending here and it requires adjudication. My lord, this is the order, my lord.
Application be served on the opposite parties. List this matter for further consideration and the same heading on. দিয়ে দাও একটা 2 সপ্তাহ বাদে।
My lord, kindly see the matter is directed to appear in the month of February. My lord.
22nd Jan. দেখো
My lord, I will also on that day, my lord, try to satisfy, my lord, how 227 is maintainable, because
serve and come.
yes, my lord. Grateful. Copy রেখেছেন, lordship.
You want a dismissal with in their presence, so be it.
Yes, it requires his presence.
I'll
There
hear
is-
you. Yes.
Because there is no scope of stay. Already,
No, nothing.
already arbitration terminated, and yes. Here the issue of law, your lordship has to
Consider it. very
consider.
thoroughly.
Yes.
Yes, call the next one.
Great. Copy রেখেছেন।
May I please, Your
22nd,
Honor, for the
22nd.
petitioner. May I please, Your Honor, for the petitioner, my lord, I'm led by Mr. Bose. He is engaging in some other court, my lord. So let it be, do it, my lord. Last direction, your lordship was again directed to serve to the other side and file an affidavit of service, my lord.
What is the order passed by the court?
My lord, last day it was adjourned, my lord. The day
Trial
was
court, trial court.
resolution of the bar was there, so matter was not taken up, my lord.
You served.
Yes, I served. Again, it is come back with the mention aggressive left.
I'll direct the learned court to hear out your application on the next date. When is the next date fixed?
Yes, my lord, 20th February.
If necessary, by preponing it.
My lord, if it is only
Within
thing, my
15
lord,
days, I'll direct the learned court to hear out your application.
but my lord, in someday, if your lordship will direct it to only the NCO to police to not to take
No,
any.
application has to be heard by the trial court. Ashwin. Affidavit of service filed into, you have served. Service
Yes,
is
sir.
there. না থাক
নয়তো তুই বাঁচতে পারবি না ওখানে।
দেখো দেখো, এরকম সব থাকবে, এগুলো কপি রেকর্ড সব থাকবে।
The envelopes all be kept
Yes,
with
yes,
the
yes.
body.
Why did you not annex it, Mr. Bose? Why?
Annex করিসনি কেন? কেন?
Yeah, why? It cannot be. It is not open. He is not saying directly.
না না, এটা annex করে দেওয়া উচিত
Ought
ছিল।
to have annexed it along with the affidavit of service.
Absolutely, তোর এটা annex করে দেওয়া উচিত ছিল।
Yes,
এরম
call the
ভাবে
next matter.
I'm grateful. And Lordship has granted me 2 weeks time. মানে I can take the server copy and I can mention, and the court bill has been directed to hear out within 2 weeks time. I'm grateful. I'm extremely grateful.
Yes, my lord, it is my lord, I am appealing for the petitioner.
Yes, sir.
I am drawing a lordship attention.
Procedural lordship's order, undertaking was given and the children have come back from Assam with their father, and father is present, my lord. They are safely living with their father. They are safely living with their father. And my lord, what happened? In the meantime, after reaching Kolkata, they have attended the school, and now they have come to know that annual academic exam is going to be held in the month of February. That's why they are.
Matter for visitation. What about the visitation? Agree to this.
Yes. Visitation, as per order of the Rani district judge.
Oh, how?
In the shopping mall in,
I am not-
in presence of the father.
I am.
What will the father do there? What the mother will interact
Pursuant
with
to your
the
lordship
child?
direction, the last occasion, this
I'll direct this situation.
this will continue. I'm grateful to your lordship.
Why? What is so difficult about it? He could go have a vacation, spend a vacation, come back.
No.
There is no
I am
difficulty.
not on
The
that.
mother can be equally entitled to, sir.
Yes, obviously, my lord. Obviously. My lord, as per order.
Ask your client. Ask your client.
I have also impressed my client. Yes,
Hmm.
because unless there is a bonding with the daughter and the mother in such a manner, I cannot ask her to take
The liberty to mention remains with the court.
Yes, yes,
You
yes.
can come back naturally. So liberty to mention is there. Disposed. Nah, liberty to mention disposed of.
My lord need not take the records on board. My lord, item number 7.
This
Item
is also a matter relating to custody. No.
My lord. Fortunately not, my lord.
So, Aniji, it's a very
Painful,
difficult.
so painful.
Yesterday, I had to sit with 1.5 hours practically to
In
get it resolved in chamber to get it resolved. Now, ultimately, things are, you see, at the end of the day, people are very reasonable. But relationship, when it becomes hard, situation becomes difficult.
Child becomes a commodity, my lord.
And
Absolutely.
people try to use it as a bond. That's the
I
difficulty.
tell you, may I share my
Yes,
experience.
yes,
My lord,
yes.
I was appointed a special officer in a custody matter. My lord, for 8. My lord, I used to play cricket in Nico Park with the children, my lord, keeping my own child, my lord, at home for 1 year long. Yes, my lord. Yes, I tell you, Lordship. My lord, item number 7, item number 8, and item number 975. These are all suits where, my lord, I am defendant. My learned friend is appearing for the plaintiff. My lord, disputes have been resolved. Applications have been filed under order 23. My lord, in one of the matters, terms of settlement has been filed. My lord, those are lying in, my lord, the learned. So kindly call for the records, my lord, through a special messenger. My lord will kindly, my lord, dispose of the suits here. Yes, my lord, the terms of settlement, my lord, needs, my lord, the original one. Yes, yes, yes. They add one line that period on consent of the parties where the matter is called an out of turn. 975. Very, very, very. Well, the cost title in 975 in the cause list is wrong. Millard will. No, I'll just supply Millard the right correct cost title. ওটা কস্ট টাইটেলটা কজ লিস্টে ভুল আছে কি হবে সেটা দিয়ে দিচ্ছি হ্যাঁ গ্রেটফুল ম্যান গ্রেটফুল ওই টাইটেল সুট নাম্বারটা শুধু চেঞ্জ হতো আলাদা নাম্বার
Grateful. Great. Great. Great.
This is my neighbor obtaining an injunction.
I am the respondent and I am the respondent in this case and I want to appear in person.
Sir, I'm not asking for any orders. I'll give a copy right now. No.
Yes, sir.
My lord, I'll just allow my learned friend to complete his. Okay.
But I just
The order.
yes, I'll
Order was never.
आगे दिने order टा था और एक खामटा था. Just one thing, if I may show. After that, my lord, the advocate. Yes, no, this is not. This is the other thing. Then, my lord, they gave us a sent it by post. 500 grams is just the documents. This is the ready, my lord, ready. Yes, অর্ডারটা দাও না অর্ডারটা দিতে পারছো না কেন তোমরা এই দেখো
দেখবো না নেবো
নিয়ে নিন
দুটো কপি আছে
আচ্ছা একটা কপি রাখো না
হ্যাঁ সৌমেন্দু দত্ত
আচ্ছা ঠিক আছে রেখে দিন আমি
I will also check with them.
No.
Let me explain you. Let us not simplify that straight away. Actually, what has happened is that the person with whom I entrusted to send it, he just forgot to insert that in the and that too, and that too, on being aware on the 19th when the application was made in the court that they have not received, I rushed personally to the court and made an attempt to hand over the papers to the learned advocates on 19th. The date of the application. On 19th, when the petition was, the application was. I know. I'm just. My lord, my lord, I have certain things to submit before this honorable court. No. I am just trying to bring in front of the court the character and the nature of the applications, the character of the petitioners, and they like. And I can kindly allow me to speak.
Why did you use the product? Why did you use the product? Your product is not before this court.
No,
now your product is before the civil judge. In the civil judge, junior division.
Yeah.
Now, I am assuming he passes an order in your division. Therefore, I am not going.
My lord. By all means, my lord.
One, he does not pass an order in your favor. You are entitled to challenge the order by your happy. But if you argue the matter here and If it was either then your right is lost. Even if it was disobedient.
No, I definitely agree to what you say.
You see, there is an instruction. Law is very clear. Law says, Order 39, 238, there are so many judgments on this. Umpteen number of judgments.
Yes.
Order 39, 238, A and B, case of expert order of injunction has to be complied with. So it is not the, you are not the first one, you have suffered this, I have also suffered this.
My lord.
So maybe, so you have the delay on the next day.
My lord, I am not in true opinion with you.
He is not complied with. The order still gets this.
Still gets it.
My
And
lord,
we found
you-
two cases for that also.
My lord,
I said, forget about name. Show me annexures not supplied. They found two cases.
my lord,
Injunction was defeated.
On this ground.
He was not compliant. The opposite party did not appear statutories, and when the matter was made absolute after
Impossible. Impossible.
my lord, I just want to bring to this court, the notice of this court, one simple thing, that the petitioner has not come to the court with clean hands. No, it's just for the information of the court.
I will hear you, but then I will not know which way. So this board is, I think that. Please say, one fix a day, I will not make this. So I will fix a day. Next Tuesday.
Monday. Oh, Monday is the date. He can, you can, Lordship can direct them to hear. Oh, yes, 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 yes. Tuesday. No problem.
In the lower court. Yeah. One more thing I'd like to bring to the notice, that is, being fully aware that 13th is the next hearing date, the petitioner comes to this honorable court to get an order. So that is one thing in. No. I never deny it. I never deny it.
Yes, I am not going to this. I will not get something based on a line which I have not. Because if I do so, you are interested in this or they are interested in this, I'm sure Mr. Choudhury will also not want to argue on minutes.
No, I don't think it's required, my lord. What? এই ছবিটা দেখাও না ছবিটা দেখাও Yes, yes, I have a sanction. See, Milord, this is the stage of construction. Nothing will happen in one. I'm sorry, Milord. Nothing will happen in one day. This is the stage of construction. Nobody works
Lord,
over the weekend.
I'd like to submit again that they are the promoters and they are making headlines again for the wrong reasons. So no, it is, I was not prevented. It was a mistake.
So,
Okay, fine. So you just,
The power to pass order, I will not fall into it, but I will also not prejudice this guy, because he may have a right to oppose you and say, do not pass this order. Both things. Both things.
absolutely. Grateful, Milord.
so for 2 days,
Set aside the order and don't pass the order unless we get it out by the. I have not said.
No.
I have said, no, that can pass anything order. Not necessarily always anything order to be passed.
Milord, that is the exception. That is the exception.
it is a matter of interpretation, my lord. I have nothing to say. I depend on your wisdom to at least protect this poor septuagenarian from the.
One will hear out. I recorded that. I got directly. I got specifically directly.
13th, but to Monday it will be heard. Milord, I will also, after the matter, speak to my adversary and, Milord, because I'll find out what is the difficulty and I'll rectify it. No, what can, Milord, we have a, correct.
My wall has cracked and
We'll
after
repair it.
repeated requests.
Milord, I am sure, I am
My
certain,
roof has cracked.
I am certain, Milord,
It is
this is,
120-year-old building.
1 minute. I am certain, Milord, this is not the first time it's happened. I have some control over the construction also. We will ensure, and I'm telling your lordship, we'll ensure that it's repaired to his satisfaction and there'll be no infraction. There has been no infraction. This is not a promoter who will infract, my lord, the building
I've
plan.
given bunches of letters. and
I
they have just
understand.
understand.
That
They have
is-
taken police to their side, corporation to their side.
I will follow it up and I'll speak to you outside the court. You can do that, and I assure
I'm
you.
going to follow it up. If they want, they should follow it up.
What can I do? Very well. I will have them call you. Yes, yes. Yes, let him go and fight. We'll go there and show that nothing wrong has happened. Yes, but Milord, I was able to settle in Milord Baliganj a similar issue where Milord, advocate of this court, her house was completely cracked by a. I had the promoter repair the whole building. That's the solution. I'm up to you. It's your legal right. Please proceed.
অর্ডারটা স্যার কবে পাবো আজকে
Server এসে
স্যার
server copy.
Yes, call the list. ইন্ডিকেশন তো নেই কি সে আছে দেখি 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 কোথায় আছে দেখি দেখো বলা আছে thereafter 1095 নট টুডে করে দাও সোমবার হ্যাঁ দিয়ে দাও নট টুডে এগুলো ডিসমিস করবো না এগুলো দেখো খেয়াল করে মিস করেছে
My lord, 1710 Miss Devanita Pramanik is appearing for the respondent, madam. Please answer.
I appear
correctly
for the
cause-
petitioner. No, I will not stand in the way, but if your lordship remembers, on the last occasion, it is that matter where your lordship had directed us to file a separate revisional application. It is pertaining to that matter where, my lord, I was not permitted to cross-examine the witness in the family court since I'm a bar library member. So that is why your lordship said you take out a separate application in section 24. I cannot pass this order. So, my lord, we have taken out a application, my lord, a separate civil revisional application that should have been there in the list today because in the filing form, my lord, the date was given. So, my lord, if this is tagged together with 4503 and your lordship will take it up on Monday.
No, you file it first then
I have filed already.
Where is
PO
the-
number 4503, my lord.
it appear in the list thereafter
And then there will be a difficulty because the matter is again fixed on কবে আছে মামলাটা? না 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 trial
since
court
an accommodation has been sought for on behalf of the opposite
it
party
is there in it is filed.
has it appeared in the list
So it,
then
in
why
the filing
making that
form, the
supposition?
date was there to.
I know unless it appears in the list I will not pass any order it appear in the list first I will indicate why you
But,
insisting
This is analogous. This is in.
But it has not appeared in the list. Which item will I direct? Which item will I direct, madam? Which item? Which item?
My lord, your lordship.
No number, I do not do so.
Procedures told us that I will not hear the can application. That is why I did not file this paper.
Yes, you file it.
See that-
But has it appeared in the list?
My lord, I have given the date today. That is strength as this matter.
Since it has not appeared today,
It will appear. Wait, when it appears, you mention. Please understand the situation. Unless it appears, I will not direct. It has to appear in the list. Call them next matter. That is why we adjourned it till 28th.
ঠিক আছে বুঝে গেছি
Mention it. It will be. I'll take
I bow down
but it has to be listed.
I
Sir.
bow down, Lord. I can
There may be defects in the application. Why will I direct it to be listed? You rectify the defects first.
No, there is no defect.
I
There
don't
is no
know. I don't know, sir. Yes.
In revisional application, generally, my lord, there are
Why?
very few.
There are so
In
many
appeal, my
defects
lord,
in so many
deficit court fees and all those things come, my lord. But in
Are Baba. Let us see. Let call Dako. Mamla Dako.
Mention this matter for enlistment of the contempt application. Lordship, the contempt application was not listed on Wednesday. Lordship, the matter was mentioned. My lord gave liberty to mention when the matter is taken up. Lordship,
Matter has been disposed of.
the 17B application was disposed of. The writ petition is pending. Now, my lord, for contempt, Lordship, I have filed the contempt application mentioned for enlistment of the contempt application.
A judgment is delivered.
In the
Yes.
section 17B, yes. That has not complied with as such, Lordship, the contempt application.
I don't have determination of the writ petition.
Of the contempt application, I had mentioned the contempt application for enlistment.
Since this court does not have determination.
But I had mentioned for contempt application.
Are listen to me, sir. Since this court does not have determination, let this matter go out of the list. Contempt list alada kore diye diyo.
Enlistment, my lord.
This is not contempt.
My lord, they have wrongly. My lord, what can
So I will take it up as it is.
No. My lord, I say, my lord, let it be listed under the contempt
It
application.
will.
My lord has released it, my lord.
Naturally, the revision, the writ petition, I don't have determination.
My lord, I have mentioned for contempt application.
I have heard you. I have directed, but I cannot take up the writ petition.
I am not praying for taking up the.
I have already directed.
My lord has released. My lord.
Naturally, I will not take up the writ petition. I have to release
My
it.
lord, it is under the application heading. No application is there. It is wrongly listed. My lord, if it is, it will go down, my lord.
Contempt has to be filed.
It has been filed. The contempt was mentioned.
Contempt দিয়ে দিও লিস্টে। They'll put it in. Contempt লিস্টে দিয়ে দিও। File করে দিও লিস্টে।
My mentioning slip was only for contempt, my lord. Nothing to-
Wrongly appears, so it has go out.
Yes. Wrongly appeared. হ্যাঁ, contempt আমি mention করেছি।
Call the next matter. Call the next.
এখানে। Lordship, I appear on behalf of the applicant respondent in whose favor Lordship had directed an application under section 17.
Pirovani, also I'm praying for not today. Mr. Shomu Mujumdar is leading me in this matter. His presence is required, Your Lordship, because they are seeking a clarification which will have effect on.
This is an application.
Lordship,
Which application?
Lordship, application is Can 2 of 2024. My lord's initial order is at page 8, Lordship. Relevant paragraph is paragraph 12 onwards.
No, where is your application?
Lordship, Can 2 of 2024.
এই ক্যান্টু লিস্টে আছে? ক্যান্টু লিস্টে আছে? বের করে দাও না, ক্যানটা উপরে দাও না। ক্যানটা উপরে দাও, ক্যানটা উপরে দাও। ক্যানটা বের করো, কোথায় আছে?
Can I hand up a copy? চার বারো 24 ফাইল হয়েছে তারপরে এসছে may I hand over till the time
Unless that application is there, no order can be passed.
no not
So
taking
then,
of an order
no order can be passed in the matter without the application. Please understand. First, the application has to be there.
he is praying for an adjournment
But
also.
without no order can be passed. Not today. আছে You want time?
Yes, Lordship.
দেখি ফাইলটা দাও। Only can do. They'll find it out, not today. You in get time. Mr. Go Calcutta next Friday. Let them take time. So because the application is not there, I cannot record any order without that application.
If I could indicate, Lordship, what
Let it come. Let them come on the next day. I will consider whether at all I will entertain the matter because I don't have determination.
Liberty has been given by
I
the
have considered it
Honorable Division Bench to prefer this application.
before this court.
Yes. But
No,
I have
no.
preferred an appeal.
I have to be given determination by the, if I have the determination then only.
Clarification of my lord's order, modification and clarification of my lord's order.
I can clarify and ask. Clarification, I have check up the list then.
Yes.
Bring in the relevant notification of the Honorable Chief Justice on the next date from the monthly list.
Sir.
Yes, call the next matter. Can go to can one. None appears in support of the aforesaid revisional application.
Restoration application.
Go through the order.
No, I've seen the order.
Difficulty is there. It is not a simple default. Mr. Chakraborty must have gone through the order.
But application
Go
is
through the order. Please
Yes,
tell me
Malad,
after
Malad,
this.
that is a
One line is there, default, but that does not mean the observations are
No,
different.
but be that as it may, this court is not inclined to go into the merits of the matter. Malad, if the court has not gone into the merits of the
No,
matter.
no, impugned order. Why?
Oh,
Although the learned court had observed question raised 47 can be was beyond this court or being of order.
Malad, that observation is against me. Malad, I know that in a section 47 application, whether what is my scope of that is on merits. Malad, can you restore it and we can
No.
Restoration application, my lord, it was.
kindly restore and hear out the civil revision application today itself. Kindly restore it, Malad. Kindly hear it out. Malad, hear it out. Malad, I request Malad, kindly hear it out.
You had appeared in the matter.
Yes, I was appearing in the matter. I am also appearing now, my lord.
Yes.
Difficulty is this, my lord, we are land losers. My lord, we have not received any amount of
Compensation arising out of?
of an
My
acquisition
lord,
proceeding.
my lord, they said this is beyond no acquisition. No, this is beyond the scope
You
of.
have filed section 47 application in which degree?
No, my lord, here is
Section 18 reference.
No. No. This is a civil suit where they had initially come for repossession of the land that the government has taken excess land. But in that suit, my lord, a compensation was given. First,
Where is the degree?
my lord, decree, my lord, they lost in the first court. They lost, and they preferred an appeal. But they lost.
And my lord would kindly take
First
the
appeal court.
order impugned, my lord, internal page 4 of title suit now of
My lord, I am.
which my
My
learned
lord,
friend has come up.
my lord wants to hear it on the merits of the matter or
You are
first
for the
appeal.
state.
Yes, state.
For the state.
My lord, what has happened is the government
How much, what was directed to be deposited?
deposited.
No deposit.
No, deposit.
Pay. What was directed to be
My
paid?
lord, PA has to be. My lord, may I just assist the court, my lord. My lord would kindly come to page. Just the my lord wanted to see the first appellate order. My lord,
No,
page
Miss
12.
Case 10th October 2023 has been dismissed.
Yes,
Miss Case 13.
13.
Now, where is the previous order? Where is the certified copy of that?
Which order, man? Which order?
Judgment is dated 3rd April 2002.
Yes, man.
Where is the certified copy? And then where is the appellate court's order?
Yes, appellate court's order.
Appellate's court order is 3rd April 2000. Man, that is at page 12.
Yes. Where is the certified copy of this?
No, I have the.
Where is the certified copy?
That has, man, this is 2002, my lord. Thereafter, there has been internal
I'll dismiss
dispute.
this matter.
My lord, but there has been I mean, we are today, man, in the restoration application. And man, then, my lord,
My lord's kind sanction to take internal page 4 of the order impugned, my lord.
Not for. Where is the direction?
My lord, direction
to pay the man, the first appellate order is at when the direction is for.
Yes. So how much is the market rate?
Man, that is.
How much is the market rate? 77.77 acres of land. What is the market rate?
No, that they
tell me what is the market.
Man, I do not know.
Are you will be knowing. Your department has published what do you call those rates? Publish the rates with the registry office.
Man,
you'll be having the rates.
Now I am not having.
Tell me tomorrow. Come back on the next date with the rates.
But
I will hear out all your application, everything.
Man,
you come back with the rates. What is the rate? What is the quantum? I'll direct it to deposit with the register general.
And allow us to. We'll do it. We will do that.
Without doing nothing.
No. Yes, we'll do that, and then allow us to have a survey. If today.
Nothing, sir.
No.
First
It's a case of unjust.
Make payment.
Yes, that's what I say. I'll deposit it. Payment and deposit are two different things.
Two orders.
There have been internal disputes. There
Yes.
Yes. There are internal disputes. Civil revision petitions are pending. Who is the actual person who is going to the
by this process, Mr. Chakraborty,
I know.
There will not remain.
My lord, I know.
He will die.
My lord, I know that.
After 40 years,
this is an unfortunate situation. My lord, when I have got this in the year 2024.
Chakraborty, learned advocate, appearing on behalf of the applicant. Will be over, sir. Don't difficulty, sir. You come with the money, I will restore the matter, I'll hear out the matter, you deposit the money first, I'll hear
come
out.
with the rates.
And what will be the interest? 18%? No, it is ordinarily 15%. 15% interest.
15% ordinarily?
Yes, a statutory rate. Under the Land Acquisition Act.
Yes, I have understood that.
You'll pay 15% and then solicium 30% solicium also. That will be included. Come back, we'll hear your matter. I'll restore and hear. Section 47 filed in the 2002 matter, section 47. What you're trying to show the court? Yes, I've taken steps. Section 47 is there.
Open submission when the when the
Initial application dismissed. No steps taken. Now you come for restoration. Another 20 years will go. 2002 to 2024, 25, sorry. 25.
23.
25. So 23 years gone already. So another 23 years will go this way.
My lord is saying so, but relay is not singularly attributable to us.
No, not singularly attributable. There are others also who are involved.
Obviously, when they had a dispute, there's a
Call the next
solution.
matter, Mr. Chakraborty, come ready with the particulars. What are the rates?
I'll come back.
Market value.
Absolutely, I'll come back. Market
30% is the solution. Also
subject to the market value, the order, but whenever
at present, today's market value.
But that is not the degree subject to correction. That is
after
not...
So after 2002 market value, you want to come, you want to take advantage of that order, you will pay today, you will not pay interest. What is the reason? Judgment of the Honorable Supreme Court. At what rate would you be required to pay interest? Pay at current market rate, sir.
I'll come back on 31st. I'll come back on 31st.
Yes, madam.
I appear on behalf of the petitioner and this is a restoration application.
Yes.
It has been dismissed on default on 4/9/2024 and we have promptly filed for it on 9/9/2024.
You could not move it before this court.
Lordship, on that particular day, the landlord advocate was actually...
No, that is all right. It was dismissed on 4th of September. The court was closed in September thereafter. When did you file the application?
On 9/9.
9 September.
Yes.
But you could not get it
No.
heard out before the court. Presentation form you listed on 11th. What is the interim order?
Lordship, in the lower court, it is for revision application.
Yes.
Should I brief on the matter?
Further crossing resumes today. Previous. What are you challenging? Which order have you challenged?
Lordship, in the lower court, they have
Why impugned order be not set aside after hearing the parties? Which is the impugned order? Bunch of orders are there in the certified copy.
Lordship, they say title suit matter and we are the Bargadar and we have in the lower court they
You are a
have
Borgadar.
Yes, my lordship.
You are
And they have
recorded. You are recorded Borga.
Yes, my lordship. We are the recorded Bargadar by the LROR and they have asked the BLRR again to reopen the case. So we have come on that, challenging that order.
How the civil court exercises jurisdiction?
It's in Nadia, Junior Division Nadia.
Have you serve a copy of the application and come back? I know they were not on caveat, but I will hear out the matter on that very date.
Okay.
Entire matter.
I'm grateful, Lord.
No point in keeping this pending.
Yes.
What is the application they had filed before the court, madam?
Revision application. Title suit.
Where is that plaint? Where is a copy of the plaint? Yes. Permanent injunction.
They applied for a permanent injunction in the title suit.
I will dispose of this matter on that date after hearing them.
Grateful, Lord.
What grounds have you taken?
Uh, So here we have stated that the Barker recording by the Learned Civil Judge Junior Division, they have no right to reopen the Barker report again because it will violate the section 11.
Originally, the revisional application, the instant revisional application, the get ready in the matter, madam. Come that on that date. I'll dispose it. Oh. The petitioner is directed to serve a copy of the revisional application on the opposite parties and to file an affidavit of service on the returnable date when the matter is taken up next. Yes, call the.
I've got the
So
Yes, sir.
respondent.
sorry, sir.
Oh, wait, wait.
But I'm for the petitioner, my lord. My lord, there are two applications pending, one for substitution of the opposite party number 3, and the other one, my lord, is for my lord, reimposition of the interim order. My lord, expired, my lord, certain time back, my lord.
Substitution
Substitution and the diet.
has to be taken up first.
Yes.
The item can.
That is, my lord, can 1.
Yes. Who has died?
Died in 2021 February.
Lord, opposite party number
And application
3.
filed in 2024 without second fighter. Without section 5.
Revisional application abatement.
Lord, abatement, setting aside abatement, my lord, upon condonation of delay, my lord, that is the, my lord, prayer.
No application filed for contempt.
No, the suit abates. Also, the revisional application would abate. Yes, sir.
Filed application for contempt.
So I couldn't follow, sir. So sorry, I could not follow. Yes, sir.
They have to file within 90 days. They have not filed it.
But I'll just
After
indicate,
90
my lord,
days.
the scenario. My lord, the revisional
No, I am
application.
trying to ascertain whether. देखिए एक बार देखिए civil procedure को. Just a minute, sir.
Substitution was.
My lord, revisional application was filed in, my lord, 2024.
2024, my lord, the revisional application was filed. Now, my lord, the opposite party number 3, my lord, died prior to that. My lord, without, my lord, that information, my lord, the revision suit continued, and my lord, from an order, my lord, the revisional application.
When the revisional application was filed, the opposite party number
3.
she had already
Pro
died.
forma opposite party number 3.
Had already died. So the date has to be recorded.
This has to be recorded.
Now, have you taken steps before the trial court?
Yes, yes. After, my lord, coming to know of this fact, my lord, this fact was, my lord, known to me on, my lord, 15th of April, when, my lord, this application was taken up. The application, my lord, the revisional application was taken up.
I informed that here.
After,
I informed that the respondent number 3.
upon, my lord, getting the information, my lord, from my learned senior friend, my lord, this application was taken out. The substitution, my lord, recording of death application.
Their man.
Yes.
Respondent number 3 is their man. So far, my respondent is.
No, question is not that. Question is
লিখেছে একটা প্রিএমটার আরেকটা লিখেছে প্লেন্টিভ
whether the revisional application in a revisional application will have it.
Yes, madam.
Or
file.
All the suit would have it. Only the suit would have it. And here, the court will only be required to record the factum of death or to substitute. If it is not a question of abatement, then the question of setting aside abatement will not arise. So that is what I want to know from you, sir. Whether in a revisional application, the application will also abate, or the suit will only abate. And that is a different issue altogether. I want to know. You are not getting the point at all. Yes, Mr. Chatterjee, will the revisional application abate? Chatterjee is here or left? Very well, very well. Not necessary. I'll place it on my next week. I'll consider it. Come back. Next week. Come back. Come back on next, unless this is allowed. Have you prayed for reimposition? File a separate application. Extension. File a separate one. Fresh application. 17, list on 17th. Call the next matter. When was it dismissed? Why will I restore it? Why will I restore it? What is your challenge in the order?
That I did not know that there was a marriage. You are I that this case for that this case I went forward.
You've not yet been evicted. Not yet been evicted. Still enjoying. Yeah. You're a capable person, sir. When was the order passed? Decree passed?
That's been responsible for 29 day of appeal.
They could not succeed in evicting you for all these years. When will you surrender? I'll fix it. Tell me, when will you surrender? You've enjoyed a lot. Paying nothing. Not a single paisa you have paid from the date of decree. Very poor. So they'll not. Let them stay elsewhere. Where are they staying? Where are they staying? Where are they staying? No, here. Where is this title suit? Suit property. Katwa. What is the nature of the property? Shop room. Poor person running shop room. What is the shop? You tell me, sir. You do not know, bro. Someone else's property and they are enjoying. Decree you have suffered. When will you surrender? Tell me. Any date? No, I'll fix it. When will you surrender? You take instructions, you tell me. What terms? You say you are poor, you are not capable. Commercial property, you are not capable to pay. 20,000 rupees shop room? 20,000 rupees occupational charge? How much? You tell me how much? No, I will not. I will not. You tell me. You tell me, sir. No, sir. Quantum, you tell me. You tell me. And whatever you lose, after so many years, I will not. You tell me. You tell me now. Assess and come back. Nothing. No directions are in these matters. You tell me now what is the figure. I will record your submission and then proceed. 5,000. According on your own showing, it is 5,000 from 2017. Naturally, sir. 20,000 you pay. You bring in 10,000 at the rate of 10,000 for 17, 18, 19, 20. How many? What is the figure? Naturally, sir. You will enjoy someone else's property. You have suffered a degree, sir. It has to be high. It is not your property. But you are enjoying it as if it is your property. You are so capable, sir. 2017 degree has been passed. There is no stay nowhere. But you are still not being evicted. They could not succeed. How? Naturally. You are so powerful, sir. They could not enforce a decree. Naturally. 18, 21, 22, 23, 24, 25. 8 years they could not succeed in executing a decree. Oh, everyone has not come. Piecemeal, in parcels. Everyone in parcel. The matter has been moved in parcel. Now, after this matter is disposed of, then you try another suit you will file. 20,000 you pay, sir. I think that is best. Take instructions, come back next week. Yes. Take instructions, come back next week. Dakho. 20,000 rupees. Oh, no, I will restore it. Everything. Come, take instructions and come back. Not this week. Dakho. And sir, one thing is very clear. 2017, you are enjoying the property since 2017 without paying a farthing. Naturally, you are not paying anything. You are not. And maybe it will appear that even prior to filing of the suit, you did not pay anything. What is the agreed amount? No, you tell me what is the agreed amount. You not. Yes. Enjoying the property. Naturally, these are old rents. How many years? Occupying the property? 50 years? How many years? You tell me. $50 years. 200 rent is 50 years. Minimum 50 years, 200 rent. Because nowadays nobody will give on rent for 200 rupees. Not even worth anything. Can you buy anything from rupees 200? Tell me. Be reasonable, sir. Ask your client to be reasonable. Yeah. Friday, next Friday. 20,000 get ready to pay. Subject to hearing them, it may be 50 also. So for the time you ready 20,000. I do not know in the it's more. In rural areas it's more because there is not so many construction. Not so many construction in rural areas. Here there everywhere construction. So you can get a shop very easily. There you can't get a shop. And shops are only centered around the railway station or the bus stand or the bazaar. Elsewhere, no standalone shops. No, elsewhere there is no standalone shop in the rural area. No standalone shop. You can't have. Nobody will buy anything from there. Yes. When was the order passed? You are for the husband. Are you making payment of 20,000? One lakh you have paid in 4 installments. You are challenging which order? How much do you earn? How much do you earn? What is your gross salary? Out of which? On you pay 30,000, madam. Sorry. Whatever, madam. Sorry. I'll dispose it of. Pay 30,000. Why have you deducted 49,000 on account of contributory provident fund? Who has asked you to deposit that? 49,000 on account of contributory provident fund. 49,000. Your salary. Then rest. How much did you take on COVID special advance? Madam, home rule is 1/5. 1/3, 1/5. Judgment of the Supreme Court are galore on this. Yes, yes. You have a child. What are you doing? Ah. Suit for divorce. Matrimonial suit. You are not willing to settle. Are you willing to settle? If you consider this is all golden eggs, then it is different. Or else if you are ready and willing to settle it out. She does not want to stay with you at end of the matter, madam. You want to stay with her? Permanent alimony, fix it up. Permanent alimony, fix it up, finish it off. How much you want for permanent alimony, you tell me. You tell me how much you want for permanent alimony. He might get 25 lakhs ultimately. If your divorce matter will end there. You are not interested to stay with her? I will record that there has been irreparable breakdown of marriage. Matter ends. Golden handshake, go away. Golden handshake, go away. Matter ends. So society has changed today. No, you cannot take advantage of this situation. Neither can they. Every month they are paying money. Once and for all, they'll pay and finish it off. Take instructions, come back, sir. Next week. I'll record all these submissions, sir. It will not be very happy for you also. If you be so rigid that you are not ready and willing for anything, you want to continue with the situation prevailing, that will not permit, sir. I will ensure that the suit comes to an end immediately. Within 6 months, I'll direct the suit to be disposed of. Yes. Very well, let the interim order continue. I'll direct the suit to be disposed of. You're happy? If 20,000 a court has passed, I'll confirm that. I'll direct the suit to be disposed of. Make up your mind what you want. That is why. Let him be a manager. You are not asking for, do not want to stay with him. You can't go on milking this man. Either you stay with this person or the divorce proceeding should come to an end. Logical conclusion. Are you opposing the suit? Are you contesting the suit? Okay, you are not ready and willing to stay with her. Tell me yes or no. I'm recording mediation failed. That does not mean the court is powerless to inquire from you whether you are ready and willing to stay with her or not. Then you consider, sir, you consider. This is not. You are ready, mediation has failed. Mediation on the ground. I'm inquiring from you, I'll record in my order whether you are ready and willing to stay with the petitioner. I'll record in my order, sir. That is why I'm asking you, do not tell me that the mediation has failed. The court is putting you a question. Are you ready and willing to answer this or no? Mediation may have failed. The court is inquiring from you. Are you ready and willing to reside with the petitioner? Give me your answer. I'll record your submission and pass my orders. Don't tell me that the mediation has failed pursuant to an order of court. Sir, your approach is bad, sir. Yes, please do not tell me that, sir. Correct. Therefore, mediation may have failed. Sir, mediation, I have to dispose of the proceedings. I cannot keep this matter pending. Why the interim order will continue and the suit will be stayed? Suit will be disposed of. With that interim order. Difficulty is that if you consider all these proceedings, the matrimonial suit such in an adversarial proceedings of this nature, these things will never come to an end. Never come to an end. You have to accept things logically and you have to consider these matters logically. You have to consider whether this court will permit the situation to continue like this. The court will not permit the situation to continue like this forever and after. Please understand this. The court will balance the equities and ensure that the divorce proceedings are disposed of if the parties are not willing to settle the issue. That's why I'll record that in my order and direct the trial court to dispose of the matrimonial suit. And I'll confirm the interim order already subsisting. Take instructions. Within 6 months, the learned court will hear out and dispose of the application. On the next week, I place it. And this is the interim order which is there. We will continue. I'll confirm this order. Situation has been prevailing. You have not preferred any application for vacating of the interim order. This situation in the facts of this case, let it continue. Let this suit be disposed of. Or in the alternative, you want a golden handshake. You want to move out. Come back. Tell me what is the settlement amount. Sit with her. Fix it. And go away from here. Think over it. Litigation will not help the parties. Both the parties will go. They are doing some work, both of them. Your client may not be your housewife doing nothing, but she is doing something. He is paying. He knows that the money that he is spending every day and the time that the client is spending will inure to his benefit. He is in position to settle on a higher side. Find out what you want. Tell me. You cannot say that you are only engaged for this purpose. Have you read your Vokalatnama? What is written in the Vokalatnama? Engaged only for appearing in the matter. Sir, don't tell us, sir. Please read the Vokalatnama. What is written there in the Vokalatnama? You are competent to do everything. Has your client signed the Vokalatnama? You are competent enough to take all steps as may be necessary. So don't say, my appearance is only limited to appearance in the matter. Please take instruction in the matter. Say it will inure to the benefit of your client only. Both of you can sit together. He is a junior member of the bar. She can go and talk to you. Yes, is she ready and will? Very well. Sir, take instruction in the matter. Call your client. Sir, call your client. Take instruction in the matter. Find out. Mediation failed. That does not necessarily. This is not a commercial cause. Mediation failed. End of the matter. No further mediation. Not a commercial cause. 2 human lives are involved. 2 persons are involved. This is not another litigation for you. Here 2 human lives are involved. Both people are young. If they cannot remain together, they should part ways in that case and find out what means should be adopted. Why your client is not ready and willing to say? Very well. I place it next week. Talk to your client. Otherwise, the same order I will pass. I'll pass this order on the next day. Whatever is there in the order, I'll continue and direct it to be disposed of. I'll not go there. Within 6 months, the suit should be disposed of. You take instructions, otherwise this consequence will happen. It's not possible for people to bear in such a fashion. Matter will go on ever after. 6 months stay is there. High Court matter pending for the last 6 months. More than 6 months. When did you approach this court? April. And 1 year has practically gone. Sir, please understand. I will dispose of this matter with a direction for expeditious disposal. Take instructions from your client, come back. Or in the alternative, you want lump sum amount for alimony. If you want to part ways, consider it. If you do not want to part ways, no difficulty. I will direct hearing of the suit. Okay? Whichever way you want. Correct? Correct. So take a chance. I'll give you one more opportunity. Come back on the next day. I'll dispose it of. Yes, Dakota. I understand. Next day. Madam, take instructions. Sit together with you. And please tell your client that I'll dispose of with this direction to have it have the suit disposed of within 6 months. Yes, find out. Yes, sir. What is your order? Next week. Next week. It will be called on next week. Next Friday. When was it dismissed? Why? Where were you? Yes, paragraph 1. What have you stated? If it is hard, it will be recorded. If the no order is also recorded, it will be recorded in the back sheet. But then it continued in the list. It went outside the list. It again came back. You're saying. It was dismissed in the supplementary list. Are you sure? Are you sure? Ascertain and file a supplementary affidavit, sir. The petitioner would submit that. You said it was posted to the supplementary list, sir. Sir, I am very particular about my list, sir. You did not say so. And it is not recorded in the petition that you missed the matter. It is something else is recorded. Yes, file a supplementary affidavit. I shall consider your submissions on that date.
That no order was recorded on that matter. Subsequently, the matter came in the list called 11.
That is why you are saying it came on the list, so supplementary list.
It was stated that form
Maybe, sir, it came in the list, so I do not know, sir. Whatever. Clarify the position, whatever you want to clarify. It was according to if it is in the supplementary, clarify the position. Sir, matter 4th of November. On that is the reopening date. The matter was listed. Your item number was Your item number was 11. Now, if you have attended the matter, then the order ought to have been passed. Some other date, then how will it go to the supplementary list? You file an application, I'll consider your statements. File supplementary affidavit. I have recorded your submissions. Yes, call the list. Sir, you have to come clean before this court. Don't try to dodge because there are too many recordings. The order sheet records under which head the matter is called on. You ought to have been aware of this before making a submission. The order sheet itself records that under which head the matter is appearing. Yes, the order sheet records under which head the matter appears. Go through the order sheet, you will understand. Don't make submissions which are not supported by facts. Ascertain facts and then make submissions. You did not say so. Neither does your petition say so. Neither does your petition say so, nor do you say so. You said it appeared in the supplementary list. You did say that. I've recorded that. That is the reason. You have said in open court, you have said that. In 5 minutes back, you have said that. I have passed an order, whatever you want to do. File a supplementary affidavit, clarify your position. Yes, call the list. Yes. November 6th. Is having heard the learned advocate appearing for the petitioner. Now, this is an application inter alia appearing for recall of the order dated 6 November 2024. No, it will appear. It will appear. Prosenjit. Prosenjit. If everything appear করবে তোমার হুম হুম application, what is the application? At the rate of at You are for the landlord. You did not accept the occupational charge. They have tendered. You want to pay, you want to accept it. Yes, you did not accept it.
I have to accept. There are not see. You can't accept without it.
Order of court is there. Order of court was there, directing you to directing him to pay. He because relationship was not there. That is why court directed occupational charges at current rate. You did not accept it. No, today order 9 rule 13 has been allowed. Today you cannot accept it. Today you cannot accept it. No, today you cannot accept it without an order of court.
Yes, complete favor.
Yeah.
Because I don't have that order in this.
Now you are asking for enforcement of the order passed during pendency of the order 9 rule 13 application stay. Allowed?
I think we must have annoyed that by an order that goes up at the report. Otherwise, it's not a judgment.
No, today is an application, Mr. Chaudhary.
I want you to be my house. Yes, I got it. No.
Where is the order? Where is the order? Order 9 rule 13. Yes, dated. Where is the property? Where is the property?
Opposite joy in Dhaba. One flat. Staying over there, and what is the most annoying act?
When was he inducted? When was he inducted? And what was the rental, lease rental? 80.
Now it's 21,000. One flat. Now what is really annoying is, I have the old house. I have Khaduri. Picking them off when he's putting Philista. I've got pictures. I came to court. I got an order of injunction. What is this? Now you have kindly see the impugn judgment. There are two below issues. Which are below. Oh, gross.
Who is Nathani? You are Nathani.
Bailiff's report in the suit shows service of notice of summons. Court below, two things are done. One is person goes with the summons, and the other is there is service by post. So one, there is service by post is received. Two, when the bailiff paid, it was refused by saying I have already received this, and this is in the bailiff report. Number three, I wrote a letter to the post office saying please confirm whether the original service by post has happened. Post office has replied back saying yes, it has happened. When the matter comes up, order 9 June 30, Learned Judge Billot ignores the fact that I have written to the bailiff, written to the post office, and the post office has confirmed that the letter containing the summons was served. That is Exhibit A, that is Exhibit G. Learned Judge Billot ignores this. Learned Judge says, I am not going to look at the sheriff's report because you didn't exhibit it in the order 9 Rule 30.
No, just a minute. But he also considers paragraph 39 merits of the case in order 9 Rule 13. So he considers the merits there. How can he in order 9 Rule 13? No, he also considers paragraph 39. Come to that. 39. The next important issue raised by the learned advocate for the petitioner is whether the opposite party, Mr. Sushanto Sen, can give evidence in a case when his power of attorney in favor of his daughter is still subsisting. The issue, the way outside said, one is
You allow expediently. During execution, come and see our submission. Get out of my property. Get out of the property. Yeah, absolutely. Get a degree in Can you see from better what you get? What are the considerations? Two things are to be decided. Can you see? Whether someone can submit, you will not know that service of someone they have to produce that. What they have tendered in evidence is the eviction notice. Only the eviction notice was tendered in evidence to show that it has been served. No attempt was made to show that the service of someone that was made by the court. The bailiff service cannot show under Article 270, even the bailiff could not prove the service exactly as made according to the law. He has to, if he does not own the property under Article 270, it's mandatory. That
postal receipts were disclosed. Evidence was not tendered. 6th August 2021 eviction notice. Kindly come to paragraph 40. I'm on that. I'm on that. Wait, slowly. Go through that. No, signature is required. Order 9, Rule 5.
Not only independent property. I will show the postal receipt which they are annexed. And those postal receipts were also not entered in evidence. These postal receipts were not entered in evidence before the suit court, also not entered in evidence at the time of consideration of order. I will show. Another set of common copy of the defendant was dispatched on the at the address of the property, and also the property was as an abundant person, learning access for the later to download backward that equal position of capital plus now this letter referring of the meeting for other all people that we lost and it will be second whether services that are defective or not. That basically was delivered to that all these questions but in proof of the other fact, opposite party has not given any evidence We are not doing any resource. At the time, what we do that. Rather, we are there upon eviction.
Yes, sir.
In order that you can show service of someone, he has only declared upon eviction.
A judgment of 89 judgment. There's a recent amendment in the order 5 rule 9 is there. Order 5 rule 9, sir. Yes, sir. Yes, sir. No, it's postal track report is there. It's paragraph 48, sir. How are you ignoring place? All the documents are there, Mr. Chaudhary. All documents are there.
Yes,
Everything is here.
everything is there in my 220. I'm going to show you lordship 3 documents. Number 1 is
I will hear you. And how much is the entire amount?
I think 125,000. That we are willing to pay. We are paying there. I want him to go. 106 notice matter. Because what he does is, after he stays away, after the degree is passed, he has order and into the 30. Then I have a right to tell. Online to 30. 106 notice eviction.
Paragraph 51 is the case that the learned court proceeds. That you only by the process server's report. Huh? No, I'm trying to understand what the court says. The learned court proceeds that what we are left with to prove summons to the suit of the suit was duly served on the petitioner is only the process server's report. Yes.
Ignoring crucial material evidence of record in the form of exhibit A, in the form of exhibit G, in the form of the minutes report. So if you have to decide, just can also look at anything.
What evidence will be necessary, sir?
We have not produced anything that is submission.
What is the requirement in law for evidence? Show me.
In order to cases that common are not
It's a rebuttable presumption. It is a rebuttable presumption. Presumption is initially on service. Now, how have you rebutted that? I have to test it out. How have you rebutted that? Not they. It is you. It's a rebuttable presumption. Presumption of service is there. Decree has been passed. No. Sir, you have presumption that it has been served under Order 5, Rule 9. Prepaid post.
That is with regard to whether summons has been served or not.
Only belief. Let's see Order 5, Rule 9. Let's see where an acknowledgement author receipt purporting. Kindly come to Order 5, Rule 9. Place it. Where the defendant resides within the jurisdiction. This is within the jurisdiction. Achha. And the suit is instituted or has an agent resident within the jurisdiction who is empowered to accept service of summons. The summons shall, unless the court otherwise directs, be delivered or sent to the proper officer to be served by him or one of his subordinates or such courier service as may be approved by the court. Yes. Now, how will it be served? 3. The service of summons may be by delivering, transmitting by registered post, acknowledgement due, addressed to the defendant or his agent, empowered to accept.
Now, this was never served and you show from the document.
Yes, that you can show. Yes, that you can show. For that, no, you are saying evidence. That's why I'm trying to ascertain from you what evidence they will lead. Affidavit is good enough. What evidence? Once they have laid the evidence while the decree was passed, proof of service was there. The unless you say, show me anything, the presumption is irrebuttable, correct? But you have to rebut that. You cannot say that he has to prove his case. No, you have to demonstrate. You have to demonstrate by someone has to come back and come up and say, no, this has not been served. So therefore, once you say so, that evidence is recorded, not been served. That is there. That evidence is recorded.
They are only stand for they are only stand for that they say this is the service of someone. Can you see what does it mean? I can book from electoral office.
Now, who has received this? Roshani Nathani. How many suits were pending?
One suit, but I don't know why.
Why did your mother accept someone else's letter? Was the letter addressed to your mother? To the mother? Roshanna Matani? Letter was addressed to Roshan Nathani, not the tenant. Tenant is not Roshan Nathani. Letter was addressed to Roshan Nathani. Let us see. No, not Reshmi, Roshan. Who is the tenant? Rahul Nathani.
They have relied upon it. Only to somehow show that service has been effective.
Wait, page 68. 68.
Somehow show that service has been effective. And the property is also different. You can see. Yet the property is short of the can see.
What is this?
This is the type copy of the original.
Where is the envelope? Where is the envelope? Your envelope you have not annexed?
But this is not a and is the 58, if 60 is the original document.
60 records Rahul Nathani. What are you saying? 68 is Roshan Nathani. I don't know, but I can read 60 is Rahul. Sir, you read it and tell me. It is Rahul, sir. Clearly, Rahul, I can read. And Mr. Chaudhary, this is your document. Page 68, your type copy.
Page 61.
Yes, 68 is your type copy. And you type out someone else's name. Very, very serious mistake. Let me go through one by one, sir. I'm not as fast as you are. I've seen that, Rahul. No, without expanding, without straining my eyes, I can read Rahul. What difficulty is, why have you typed it out as, what is this? Rashmi? Why have you typed it out? Naturally, why have you typed it out?
And the address is also different. We don't see that. That is the cell phone property of my mother. That is the cell phone property of my mother.
It is Bidon Street. Address is not this. Different address. Very well. Ajay, let me then ask Mr. Chaudhary to respond. Mr. Chaudhary, show me how have you served. You show me how have you served. Take your seat.
Court serves by post. Court serves by date.
Where is the decree?
Decree is at page 63. Date June 2022 at page 63. I did not come to page 65. The suit was filed on second paragraph at page 65. Suit was filed on 28 July 2021. The summons was issued to the defendant accordingly. The defendant, in spite of receiving registered post summons on 6th August 2021, did not appear to contest the suit. That as per various reports, the defendant refused to accept summons to court. Accordingly, suit was sent to the ex party hearing. Now, my lord, I want your lordship to see the bailiff's report, which is at page 167.
Yes. Yes.
Right? And if you take it since already
Where?
other than halfway down, other than common post office.
Just a minute. আদালত
তাই আমি অর্থ পক্ষে রসিকরা আমার গ্রহণ করি। So because I have already received from post, by post, I am not going to accept personal service.
What is written on the top? Pankaj Malhotra.
16th September 2021.
What is this?
And this is part of this. And this is by Shukumar something, common baby. Shukumar Kashmir, common baby. Now, so two things become clear. A, that there was the lady concerned, accepted the summons, and thereafter when the baby again went, because law court not two things happened. He is sent by the court to post, and then the baby also goes. Now, please see the postal receipt and the acknowledgement card of service to court. Page 58.
No, this is not service through. Yes, this is service through court.
Service to court. We have done size over as per your notes. Page 58. Kindly see to Rahul Nathani and to the suit property.
168. No.
58. Just 58.
Yes.
But this is the postal receipt. This might be a certificate number, SPLR Swarumi, after number certificate to Rahul Nathani, 32H, Post Road, SP Road, 370020, to suit property from Second Civil Judge, Kolkata. Now, my lord, and this
You could trace out the AD.
we wrote to the post office and got a confirmation.
Up to now, nobody has been able to trace out that AD.
This is also clear.
He can't trace out the AD.
The PC page 59 now.
Yes.
That the same numbers the recipient carry 8 and 6 IH actually done. Nowadays nobody looks at it. Item
Yes, tracking report is sufficient. Yes.
5th August 21 item book, 5th August out for delivery, then item on hold, door lock at 14 minutes past 3, then on 6th of August at 9:46 again out for delivery, Then on 6th August, 146, item delivery confirmed. And now we are kindly see.
Did you write any letter?
Yes, page 168.
Yes. What is the response?
The letter was written by
Yes, Department of Post, what they had to say?
I have posted a letter and
Ah.
written by speed post
Rahul Nathani.
It appears on the poster that report that the delivery is controlled on $6. Please intimate to us receipt the said letter as per item. Your intimation is required to produce the code. Now before my.
This is exhibit. This is exhibit.
This is exhibit even in.
Exhibit. No. In the suit. Order 9 rules. 170 exhibit A.
Just please see page 10 of the improved order.
If you want to make submissions, then I can hear you. I've called upon him to prove his case. This is exhibit F. 170 is exhibit F. Bunch with 170 read with 168 both.
168 is exhibit F.
And 170? Very well. 168, 170 what were exhibited. 170 was exhibited. Marked exhibit number G. Can you tell me the date on which it was exhibited? No.
Yes, from page 10 of the decree.
Yes.
Of the ordinary.
Yes. No, you tell me the date. I'll mark it here. Very well. It's exhibit G. Exhibit G. And 168 is exhibit F.
I think my document is not state. No, he's not. Received copy of letter dated 1st September 2021.
Yes, that is 168.
That is not exhibit A.
This is F.
Yes.
Then 170.
And 170 is original letter sent by my advocate. Sent to my advocate by postal department.
G.
4th September. G.
Very well.
He's right.
No, sorry. So G. So therefore.
That was very important.
So there are two documents. One is F and one is G. Both these documents have been exhibited. Apart from that, wait just a minute. Apart from that, yes. Page 58. Part of the decree. Yes, suit records.
I have to exhibit it again. We do organize and I thought we don't even take evidence.
And 59 was also part of the suit records.
And for my management says that look, when in your letter you said I have posted, and the postal receipt says district judge, civil judge has posted. The lower court practices you posted and you go and submit it to court. The court officers don't go to posting.
Yeah, I understand. Because this posting is done by the advocate himself. Because they issue it, they seal it and hand it over to you. So you have done it. But you will never get back the AD because AD comes back to the court, but it's very difficult to trace it out. But track report is there, so that is fair enough. Thereafter what? This is the postal part. And the bailiff's report is there. What is bailiff's report? Form part of the records. Was it independently exhibited? Was the bailiff examined? Where is the examination of the bailiff?
I have the summons paid from Alipur Judges Court. I serve summons which are provided for closing service. I am instructed to serve summons upon the Honorable Assembly at the back page of the summons in my handwriting. I have reported that I found the defendant and that he refused to receive the summons as he has already received the
Yes. Anything important from the cross-examination? According to you? I'll hear from him on this.
256. Next page. In cross-examination also, here he is confirming
For 32H, Sharad Bose Road is the three-storied building. I found Mr. Nathani at the second floor of the building.
kind of good, I cannot
Not
say.
necessary. So,
Say below that. The summon he told me that he had already received the summons to
where?
clear 4 lines.
Yes. I got it.
Summons which I tendered to him for receiving.
He remembered everything anyway.
Now, there is a lacuna in his report. When somebody does not receive, kindly will not see the civil procedure code. 17 order 5.
Affixation.
Fixation and should have written the argument is that when you get a witness, address also. A witness, what is the effect of a witness without an address?
That the witness's address was not there. Malhotra, some Malhotra.
Now, that doesn't invalidate service of summons. In any case,
No, that may not invalidate service of summons, but that may invalidate certainly the bailiff's report.
because if otherwise court is able to come to a conclusion and the judgments on that also, then yes, it is desirable that you follow it, validate. If otherwise it is there. And in any case, in this case, post.
Yes, post is there. So post is there.
This is why go on any of this. And order 9-13, very importantly, second proviso says that provided further that no court shall set aside a degree passed ex parte merely on the ground that there has been an irregularity in the service of summons, if it is satisfied that the defendant had notice of the date of hearing and sufficient time to appear and answer the petition. It is received by post. Nothing else is important. Exhibit FNG proof is received by post. The original postal slip is a part of the suit record. Now, without going into a prolonged argument on the judgment, exhibit FNG is ignored, which is not the
Does not consider in his judgment the exhibit FNG? No, I was reading the judgment. Relevant portion.
Apart from knowledge, paragraph 47. Paragraph 46, paragraph.
Yes.
47 to 49.
47, 48 I read.
Okay. 47, my criticism is that why infer? Because the lordship, the learned judge says, thus fact remains petitioner failed to agitate properly when for the first time he came to know a decree has been passed against him. But the insults have been in the absence of any evidence to the contrary. It is to be inferred that on 25th December, when the opposite party went to the property and asked the petitioner, why infer? Or even to infer that he for the first time came to know on 25th February. Because second court infers.
Yes, that is okay, all right. No. It could not have, because it was for him to demonstrate when he came in.
Then the next paragraph. Now the main contention of the parties is that he was not served with summons of the either through court or through registered post with AD. He mentioned here that the opposite party has submitted that it was service of summons upon the September 21 was dispatched by an envelope containing the summons deliverable to Pigeon Street Postal. That report was obtained from website of India Post. Item was reported to have been delivered to Roshni Nathani on 10 September 21.
From where he gets that name? From your document. From your type copy. No, from your type copy. From his type copy. Fact report is Roshni Nathani. Who is Rashmi? Rashmi? I see item delivered to Rashmi. Very well, fair enough. No, Rashmi has accepted. Address to Rahul. Yeah. Delivered to Rashmi. This does not necessarily mean it was addressed to Rashmi. This is office of the Bidon Street. Okay. Yes. Yes, both.
So we issued two
Notices.
with two separate postal state numbers are there on record, two separate.
Even license agreement has that address Bidon.
Over there is other receipt. Over here, you have receipt. It also has two addresses. I just indicate that
Rashmi Nathani received it very well. Mother, anyone from the household can receive a letter on the whether it is addressed. It is not an office.
And given license 402, 402, license address is 1A Kashmir State. And plate also has 1A Kashmir.
Where is the plane? You said plane. Where is the plane? I've got it. Page 38. Anyway, I got it. Sharad Bose Road is 32H. Very well. No, Sharad Bose Road address is there. And Kashi Ghosh Lane address is there. But no Bidon Street address is there. Oh, Bidon Street Post Office. That's very well.
That's why it says Bidon Street.
Yes. Anything else?
And when the Lordship comes back to the decree, I just show your Lordship the two separate postal states also. But may I just quickly show paragraph 47 of the ordinance?
Let me get an overview from him. I'll get back to you, Mr. Chaudhary. Yes.
Please come to paragraph 48, which goes on to the second page, because I don't want to read the whole thing. All these 7, 8 lines from the top, all these postal receipts and track reports were filed in title suit number 645 of 2021. So the learned judge recognizes that all of this is there in the records of the title suit, but does not take note of it and consider it in the judgment. Now we see the next sentence. But in proof of the above fact, opposite party in this case has not given any evidence that he has referred letter in 11th March, postal initial receipt, ID card, etc. All of this is there in the suit. And that's number one. You can't ignore the records of the suit. Number two, even if you ignore the records of the suit, Exhibit B and Exhibit F and Exhibit G of Order 9/213 is there, which shows that the original summons was served on Exhibit F and G alone. It's enough. Number two, and number three, crucial evidence. Court should be kind that if there is a mistake, if you feel that no, suited or that you should again exhibit or you must exhibit in an online proceeding, court can take notice of various report. Under Pillar, it used to be, I think, 136 of the Evidence Act, 165 of the Evidence Act. Now it's BNS Pillar 168. Crucial evidence. 106 notice, no defense. Admitted rate is over 10,000. And for 4 years we are doing this.
Yes, sir. So once, according to you, once you file an application on Rule 13, the plaintiff has to establish once again the factum of service simply because an application has been filed. That is a different issue. But will the court not consider the records of the case while deciding an application under Order 9 Rule 13 when the same touches upon the factum of service of summons? The question that falls for issue for consideration in application for Order 9 Rule 13. Yes, leave. Yes, you show me. Summons was not served, matter ends there. Two things. Either you can show me that summons was not served, or you can show me that you had no notice of the date of hearing when the decree was passed. Assuming that you had summons was served also. But that is a very difficult part for you to overcome unless you can establish. No. That is a different thing. Assuming, say, a notice was served, summons was served, we were appearing in the suit, for instance, and the court all on a sudden, without notice, decided it. There comes a second limb. But here you have never appeared. You chose not to enter appearance. So, assuming you are served, because summons has been served, assuming summons has been served, and you have chosen not to appear, then you cannot take advantage of the second part. So you have to establish your case on the first part only, that summons has not been served. If you can go through the fact and establish, no, summons has not been served on you, you are out of the woods. Now directly come to what Mr. Chaudhary has shown. Adversarial proceedings, he has shown this. You need not travel much further. It will be very easy. You answered directly. That's why I asked Mr. Chaudhary to answer first. No. Page 38 first. You are the defendant. See the two addresses. Answer me one thing. This Kashi Ghosh Lane, Biden Street PO. Where is Kashi Ghosh Lane? Calcutta 7,06,000. Where is this? Don't, then why are you saying no? Tell me that you have to check it out. Page 53, the answer is there. Before saying, sir, you straight away said no. Page 53, pin code 7006. See the pin code. And you see the pin code. That is why I wanted to inquire from you. I am not concluding anything. But facts have to be recorded by this court, whether this is under Biden Street PO or not. So therefore, it is Biden Street. First part over. Now come to the second page. No, I'll come to it. Just you respond and then I will permit you to argue. First, let course queries are there, certain queries. Page 58. Is it part of the court records? Yes or no? May not have been exhibited. Part of the court records. No, it's part of the court records. Fine. Then come to the next page. Page 59. This is part of the court records? Yes. When the decree was passed? After this date? No, no, after this is after the suit is filed, 28th June, 28 June 2021. So this is in August, after filing of the suit. So it cannot be that it is a notice under section 106. Yeah. So no, I will hear you. I'll no, no, it shows item delivered, confirm.
Because I earlier just 1 crore below that. Item on board door was locked. Door was not locked.
You have seen those postal track reports where it is returned to the same office? You have seen those track reports. I'm sure you have seen. In this professional career, you must have seen. What is recorded there? Yes. No, that is different. With item delivery confirmed will not be recorded. It will be recorded, return to that post. Return to SO. Return to SO. Anyway, it is from the SO, same sub office. The veracity of this document will be considered later. First of all, answer whether part of the records or not. Not part of the records, not consider that document. That's it. Very well. Page 60, part of the records. I'm only testing out what Mr. Chaudhary had submitted. First, yes, very well. Next, come to page number 168. 170. No, 168. Exhibited 170. Exhibited. Now you make your submissions. You make your submissions. You take your time, you make your submissions. I'll not stop. But I wanted to know whether these form part of the court records or not. Yes. Yes.
Is there addiction dependent on when the postal department went to serve, it was found that it was last later as number in data from ISO on which
I remember this contention of yours. According to you, this has come back.
The delivery location, data from ISO at the clock. Delivery confirm $6. It has come back data from ISO because it was the practice of the post office. After 1 month, it shows that the person definitely noted his name and mentioned just 1 month before that.
Not always.
This is the because that is the on 5th August it was found that the road is blocked.
That is a different argument, but not always it records to whom it has been delivered. It records item delivery confirmed. In several occasions, you have seen this. So don't hold on to straws. Make your argument on facts which are acceptable, like the one you indicated, that it has been served on Reshmi, not served on the Rahul. So that is one aspect. But if you want to hold on to the straws and say, no, this is actually returning, it is very difficult to accept it. It is very difficult to accept, sir. Probably you can make many submissions, but you will be knowing which submissions can hold. This is so far as this place is 7,20,000. So far as Beaton Street is concerned, it is delivered to the mother. What is the requirement in law? It has to be served directly on you, personally on you. Not 106, summons. These are summons. These are all summons. Do you say that these are 106 notice? No, these are all summons. Is it? Anyone? Your mother having any strained relationship with the mother? No. You don't reside. From where did they get the address in the plate? Please, sir, I don't disturb, sir. Where is the license agreement? It is annexed. Yes. This address is there. Where is it, sir? 1 Kashi Ghosh Lane. Having permanent residence. Page 198. Cool. 198. Page 198. There is license agreement copy. This is the one. So this is your address. This is one of your registered address. You cannot say that you are not residing there. Then why did you incorporate this in the license, leave-in license agreement? Where have you intimated them that you have changed your address? Where is that intimation? Leave-in license is in the respect of the Sharat Bose Road only. License agreement concerns which property? Sharat Bose Road property. So naturally they have sent it there as also to your permanent address. Difficult on this.
None of these documents at the time of getting them by the because if I give that sound to the first should have been there to produce the document or the court to come to a conclusion. The court is not aware of this postal practice or how the court will come to finding that case. I don't have this. Court has gone on the decision of documents to at the time of getting. The kindly see whether they have filed written objection to the order. If the written objection of therefore that is to go. The record of the summons was if the court does not have the documents in front of it, how do the court from the kind can see the record of including detailed order can see from page data 41. That is what the court has said that they are not making any attempt to write those documents or to produce the documents or at the time of the data copy. Nothing was before the court. You are producing a document regarding service of summons. You also naturally get that case.
Decree has been the difficulties. Only thing I mean very expressive. You are aware by this now. Decree has been passed against you, and in the decree, prima facie satisfaction of court is recorded. Not prima facie satisfaction of the court is already recorded of service. Otherwise, the court will not pass a decree. You have to understand. So you have to dislodge that. Try and understand. You have to dislodge that. The court records it was served. Can the court ignore a document which it had already relied on for passing a decree? Everything was there before the court. Otherwise, why will the court pass a decree? Unless I am satisfied that the copy of the petition has been served on the opposite party, why will I record despite service does not appear?
That case 58 and 59 is only considered. Later sub Russian other is not free. It's second first right of so only page 58 and 59 has been
Why? Summons was issued to the defendant. The defendant, in spite of receipt of receiving registered post summons on 6th August, did not appear. 6th August summons, and the other one is which date? Date.
10 September. 10 September 20. That does not find mention.
I see.
So page 59 is the letter which I showed.
You say that this has returned. This is page 69. 59.
And delivery location also show that it has been delivered in a sort of flower.
Yes. Just come back once again. Page 50. $69. No. Yes, 65 is a decree. Which page is that letter? That postal receipt? 59. 59. Just a moment. So this, according to you, has come back. Rahul Nathan, Biden Street.
In September,
And that 168 and 160, 168, 169 and 170 are in respect of September letter, which the court did not consider while passing a decree. And this, you say, has come back, has returned. And what is your submission on the current status? Page 59. I can come back once again because this is your only case. No, please understand, sir. Sir, you say that item was booked from LR Sharoni on 5th on 1100 hours, 11:33 hours, correct? Now, the next recording is item bagged 1409 hours. Item received is 1411 hours. All are LR Sharoni. Then out for delivery 1423 hours, same date. Then 5th August, 15:14, on hold, door locked. Kindly come to the next date. First of all, come to the 1423 on 5th. Out for delivery, you get the noting. 1423, out for delivery, you get it. Then on hold, 1514. Next date, on hold after that. Again out for delivery. 9:46. item delivery confirmed. If your case I have to accept that it has been returned, then there has to be at least one more recording, either refused or on hold or door locked, and thereafter it has to be received. But it does not say so. It says item delivery confirmed. You have to explain this. Yes, yes. No, 5th August. The 5th August. It is all right. So it is another matter for you also. Why will you make incorrect submissions? I'm not on that. So, yes, that I understand. Now, in my copy, it's very clear, 5th August. So therefore, apparently, prima facie it appears, if your contention is to be accepted, then there has to be one more column which is absent here. So why will I not accept this as a delivery on you? No. This is only one of the points. The other points are there. So since you are submitting this, I am testing out your point. Why will I not accept it as a delivery on you? Because it is out for delivery and item delivery confirmed. It is true that there is no letter of confirmation issued in respect of this document. That is, no, that is 4th September. 4th September. You check up Mr. Chaudhary. That is a different one. That is a different, I've checked up. So it is true that there is no confirmation with regard to the. No, if it is there, you tell me. If it is there, you find out and tell me. If you, the documents you have showed, I have tested out from him whether they are part of the records. He has admitted that they are part of the records. Page number 168. That is your letter 1st September. Correct. This is 5th August. You are right. Same document. Now come to the answer. Come to the response. Oh. I see. A same one. I see. I missed out. Yes. Okay. So, okay. This is confirmed. Yes, Mr. Sir, this is, you had also shown me, I had proceeded on the premise. So this is in respect of the same one. So therefore, you have received this, and these are all exhibited documents. I exhibited G. Yeah. Correct. And FNG is already disclosed, exhibited. FNG 168, 170. Those are different arguments. You will make those arguments. First, let us understand the facts and proceed. Testing out on your documents. So you received this. Prima facie postal authorities from this, it appears you received this. The only lacuna in here is the person who had issued this letter has not come forward, or the person who has received this letter has not come forward.
Only document at page 68 because it's the same by his own advocate. But 170 product. That's why the court said that there is want of evidence. Court said that there is want of evidence. Whether this letter has been served or not, that is not proved by page 170. That is not proved by way of page 170. He has relied upon page 170 to show that the postmaster chair has said that it can the language appears to have been, he has not given confirmation He has said that it appears to have been there. They are giving a statement, one-liner statement, it appears, I'm not sure of that.
This is a registered post. Now, a registered post is also required according to you, or is also required to be proved by the person who has delivered it. Because these are all speed posts. All speed posts are registered posts. Now, a document which is sent by registered post, according to you, is there are rules. There are postal rules for this. So far as speed post is concerned, there are postal rules which raise a presumption that it has been served at the correct address. This is not an ordinary letter. But your primary contention fails that this was not served by the, no, not served, that this was returned to the SO. It is apparently does not show it was. I'm just indicating to you. I am not made up my mind, but I'm indicating to you so that you can respond. So that you can respond to what I'm saying. I'm otherwise very expressive, but so that you can understand and respond to that. He has understand what is going through my mind. I don't want to hold it back and ultimately deliver a judgment. No. Yes. So where you stand, sir? So far as that letter is concerned, that letter was not returned to the SO. Not returned to the SO. It was delivered. Maybe you can argue that it was not delivered to you because he has not attempted to prove it. He will answer.
Without objection, ever prescription. Without objection,
These are without objection.
Without objection.
160, 168 and 168 and 170 without objection.
Let receipt copy of letter be marked exhibit A. Let original letter be marked exhibit G.
Yes, sir. No. Ascertain this fact and tell me whether it is without objection or not. No. Now the matter is going on, sir. What do you have to, sir? It is everything is on. No. It has to be objected at the time of exhibiting. Subsequent objection is no objection. And if it is objected, the court has to record such objection in the order on that very date. Subsequently, you cannot object. You cannot say, I leave it to the court. Who is he? And then he is deemed to have been aware of everything. Very well. So only on the point whether you had raised any objection. Assuming you have not raised any objection, that will then what follows? Then the contents go. No, you will be certainly citing judgments, but first of all, we need to see the facts. So judgments will only assist us to come to a, without the facts, how do you do on the basis of judgments? Today, identify the facts, complete your arguments. I will give you opportunity to rely on judgments. That is different. But here, this is a very vital document. This would have demolished your case. And if you have permitted that to go through, can you question the contents thereof? A very vital document. And what Mr. Chaudhary is saying, I've just recorded it, that exhibited without objection. From where you are saying the issue, deposition, nothing recorded. Wait, page.
the position of that day and verified copy of the position 259, your lordship.
You show me that. I'll see you. I'll see you.
Document goes to be the existence is admitted, but content obviously denied.
Page 259.
Let the received copy of letter dated 1st September marked as executed. The original letter the original letter be marked of the requirement be marked as exhibit G. And kindly see the cross examination.
How is he concerned with the degree whether it is sustained or not? The last line of the evidence, 259, before the cross examination. No. I pray that the decree passed. Who has exhibited this? Oh, plaintiff. Very well. Very well. Sushanta Sen.
Definitely that logical see cross examination up to page 263.
Where is your suggestion, sir, that this document is don't tell me, sir. Yes, in the form of answer, it has to go in, sir. You have to make out your case and place it on the other side, sir. So show me that. The answer is there, or naturally. The learned judge will record the answer, what is given. So you can make out what was your suggestion. You have to place your case to the other side in cross-examination with regard to this particular exhibit. Where is your case on that? Show me. No, not on this top. No suggestion. No, on this, no suggestion. And if it is recorded, answer is recorded. He will not have yes. Yes, that is the suggestion. That is the suggestion. You have done that. You have done so many cross-examinations. So what will appear from the recording of the court. It's like this is your suggestion. Not a fact 2000 is the yearly tax. A suggestion. You suggested. You suggested that 2000 is the yearly tax. He said no. And not a fact, since 2014, I am taking rupees 4,000 towards maintenance. Suggestion that you are taking 4,000 towards maintenance. You can easily make out, sir. Yes, so you did not raise any questions on this. Exhibit, like you questioned D. You questioned exhibit D. Let the initial signature witness exhibit first page signature be marked is 1 and 2. You, yes. You had accepted that. Nothing on the sofa. No, you have to place your case on the other side. We have also not put any suggestion. Anything else you want to show on facts? Yes. Bailey's report, there are discrepancies. Mr. Chaudhary had showed me that the witness, no, means the witness address is not there. Huh?
And also the report has
Yes. Even without the Bailey's report, you are still not out of the woods. That is the difficulty, sir. Even without the, assuming if I discount the Bailey's report, you're still not out of the woods. It is not that mandatory that bailiff's report is required to support their case for them to establish that summons has been served. You ought to demonstrate A, summons was not served on you under any circumstances, B, you had no notice. Summons had not been served. So B goes, B discounted for the moment. You have to establish A, summons had not been served. And you had no knowledge of the proceedings. Now, even if I consider you had some knowledge of the proceedings, how can you ignore this page number? What is that page number? Page number 168, 170, 168, 170. We are exhibiting. Bring judgments on this and show. Read with page number 65, 59 and 60. No. Those line of cases is not necessary, sir. You don't. You can start from line of cases, may start from 1920s. They don't start from line of cases. Yes. Are you ready with the judgments? Yes, show me judgments, whatever you have. Facts, anything else you want to demonstrate? If you want to, entirely up to you with the entire judgment. If you want to, yes, I will. Entire judgment. Show me, yes. Why will I stop you? It's a 3:30, I feel. Yes, this matter is continuing. I cannot take up other matters. You will say without jurisdiction. Without jurisdiction.
This matter starts 28 is and Justice Gane's name is that now I will
Yeah. No, even Justice Jayantu Kumar Vishwas never used to take up matters. Never after. There is a long story to that. Yes. No. Because there was a reason, different reason altogether. Because he used to always take up matters. He used to always sit down and take up matters. But something happened, so let's not go there. Thereafter, he stopped taking up any matter. Yes. You were there, very much there. So unless both parties are there, yes, so many things are there. So let's not go that far. Come back tomorrow. Not tomorrow. You tell me a date. Enough indication has come from Mr. Chatterjee, you see. Yes, tell me a date. Both the data. Again, Friday in the afternoon. No, I'll keep it in the Friday in the afternoon. But if I feel like I'll not take out, I did not take out. Let it remain in Friday. Friday at 2. Monday, I would love to hearing matters at 10:30 in the morning. So that is the best thing. That is the best thing. Monday 10:30, if you like, I would like to hear this. No, it's Friday. Friday. Friday কত তারিখ হচ্ছে? This is an application I am hearing out, but I will be hearing out everything. Yes. I would have concluded had Mr. Chatterjee not intervened. Heard the learned advocates appearing for the respective parties, post up. This matter for further consideration under the same heading on ওই শুক্রবারের ডেট দিয়ে দাও না লিস্ট নয় let this matter be taken up for further consideration under the same heading on 17th at 2 p.m. So it will not appear separately. Unnecessarily, it's not necessary to print the list. As it is, there are এগুলো আছে এখানে